police print out their physical copy of the paperwork,
Yeah.
they should get the same information that the magistrate typed in.
Right.
That's just standard.
It should be, but it didn't go through that way. So
It did go through that way because what I can confirm today, if you're worried, is that according to the information, which I can get confirmed by the magistrate, is that you were acquitted of the charges. Now, the reason why that's important is that if you were acquitted of the charges, they can't come back.
They can come back, and I can pursue the acquittance as a free man that has no charges on him. But if it was discontinued, then I can't go and raise damages on the matter and injuries and the rest for compensation.
Well, look, that's a completely different issue. That's going to be a civil issue that you're going to need to follow up.
Yes, it's not completely different, sir, because they're giving me discontinued, and they're giving me acquitted, which is illegal. They have to be the same since they were in a court of law. Yeah. So one of them is wrong. That's
exactly. And I agree with you. What we can do today is have the matter called up.
Yes.
I'll ask the magistrate what she has on her system about that.
Yes.
However, now that you've ordered the transcript,
yes.
Even though the proceedings seem to be at an end, you can still recover this transcript and have a copy of your own and find out what happened.
Yes, that's true.
And that's why I suggested that you do that.
Yes, I got. It's coming, I think, in 3 weeks or something like that via the mail.
Yeah.
So it takes a bit of time.
Yeah.
So up until that time, I wanted to know what was the verdict.
Yeah.
From the judge.
Yeah.
Not from the prosecutors.
Fair enough.
Just because the prosecutors had a different answer to the clerk.
Yes.
That's the only reason. Otherwise, I wouldn't have relisted, sir. I would have taken, if the two answers were the same, I just would have walked out of the court.
Yes.
So
it's a fair question you ask.
Yeah, that's the only reason I do that. And also, I would like to put forward to the judge, since the judge asked for evidence for a month, and then we came back with the blonde Judy lawyer that you talked about, the one before. Yeah. She went in there and she said that she's asking for 2 weeks adjournment for the prosecutors, which I didn't ask for.
Right.
She asked for that.
Yeah.
The reason she asked for that is because I was sitting here and she said, she opened the paperwork and she looked and she said the last case is with orange bearded Judy lawyer, and he asked for the evidence. Yeah. Did you receive it? I said, no, I didn't. No. She said, oh, and she went and seen the prosecutor, came back and she said they're asking for 2 weeks adjournment. She didn't tell me why. Yeah. Once we got inside the courthouse, they said that they're asking for 2 weeks adjournment because it's not on the USB, which is falsifying the evidence and fraudulently.
Oh look, I can't answer anything. Mr. Bahari, can I finish?
Yes.
Thank you. Mr. Bahari, can I finish?
Don't interfere, sir, because this is a criminal act.
Hang on a minute.
If you cut me off, you're interfering with my telling you.
I wanted to defend my colleague. I told you the last time that my colleague did the right thing.
So your colleague is not in my speech. I'm talking about the illegal act that happened.
Okay.
I'm not talking about your colleague, sir.
Okay, my colleague did what she was required to do on your behalf, which was to get information for you.
Okay, I didn't ask her to get information. She acted on her behalf. When we went in there, she acted on her behalf and the prosecutor's behalf.
Okay.
I then asked her straight away, I made a comment. I went, like that in the court. The judge looked at me. Yeah. She didn't look at me. She kept looking at the paper. So it slipped by. Then when I went outside, I found out that they didn't give me the evidence and they didn't say it in court either. So neither did my Judy lawyer tell the judge that the evidence wasn't handed to me, because she thinks it was. Because they said, the prosecutors said that they didn't put it on a USB only, but they've handed it to me, which is falsifying evidence, sir. So that's what I'm going in to tell the judge, that I never received it from the start. Yeah. They might have had a problem putting it on the USB, but they also said to you, ma'am, that they gave it to me. Therefore, you asked me to sign this piece of paper here, ma'am, which is the bail.
Yeah. Look, I can't help you with anything about that.
I'll go inside myself.
That's all right.
I'll go in myself. I just want to say that I came to you, did the right thing, you made notes last time on what I said, and this time I'm doing the right thing too, according to the law of the court.
Yes.
By turning up here and on the day.
So what you need to ask the magistrate first and foremost is whether the court acquitted you.
Can I get a pen?
Yes, sure. Did magistrate acquit you?
Yes. Was it that magistrate that acquitted me, first of all?
That I don't know.
You don't know, okay.
Or
discontinued.
what you need to ask, can you read my writing?
Yes, I can.
Did the magistrate acquit me and find me not guilty, or was no evidence offered under Section 25 of the Criminal Procedure Act?
525?
Section 25. Yep.
Section 25. So
Yeah.
take away that 5?
No, that's a S for section.
Right.
Section 25.
Section 25. Okay. And
Even if that...
And that's one question, isn't it?
Yeah.
I say that together.
Yeah. Well, you can hand that up if you want to.
Yeah. That's the question.
The duty lawyer has written this down for me.
Right.
Did the magistrate acquit me and find me not guilty, or was no evidence offered under Section 25 of the Criminal Procedure Act?
Is there any other questions I should ask?
Not really.
Not really. Is there anything that I should ask about the fact that I was recalled without being...
Yes, you can raise that. You can say, it's already in your application. It's already in your application that you attended on the 7th of August and signed new bail to appear on the 21st of August. But yet when I arrived to court, I was told by the clerk that I was acquitted. But yet the duty lawyer received an email from the prosecutor stating the case had been discontinued, which is conflicting. And I was not allowed to see the judge on the 21st, and now I must reapply. Yeah. So what you need to tell the court is that you came to court on the 7th. It originally got put off to the 21st, and you can show them your bail undertaking.
Yes.
But for some reason it got recalled in your absence.
For some reason, that's what I'm talking about.
Yeah.
Do I get to ask what the
Yes,
reason
you
was?
can ask all of that.
I'm allowed to ask. So
and then
what would be the question that I should put forward?
you just want to ask the court why the matter got recalled again, why you weren't there.
Whilst on bail?
Yeah. Yeah.
After being sent home?
Well, after being sent on your way.
Yeah.
Yeah.
Can I write that down?
Yeah, sure.
I'm not going to forget that for sure.
Yeah.
That's one question. That's the title. Second question. Why was it recalled?
Yes,
I left.
After you left, yeah.
After I left with bail. New bail. Is there a difference between an old bail and a new bail? I was made to sign a new bail on that day. Does that make any difference?
Shouldn't do. No.
There is no difference.
No, I don't think so. I don't know why you were asked to sign new bail on that day. I've got no idea. I've got no idea why that would have been the case. Right.
Can you do that in custody, mate?
Yeah, okay. Sorry, Mr. Harry, I just need to leave the courtroom for a while.
Okay.
My room. So I just need to grab my pen back.
Okay.
So if you just take that outside and I'll come back and see you in a minute.
Sure. We're not going to get called in now?
No.
Okay. Do I have time to go for another cigarette?
Yeah, sure.